Hello, everybody. Good morning, good afternoon. Welcome to Orange Tree's quarterly webinar on compliance. I am Jeff Ernst. How are you doing? Hope everybody's having a fantastic day. Heidi Seaton is joining me today. She'll be talking here in a few minutes. That's Heidi over there. We're just talking about the wonderful office she has, the bright orange there about midway up on that credenza, and that wonderful saying, just a little bit higher over her shoulder. So we're looking forward to another great compliance webinar. Heidi does a fantastic job keeping up with all of the particulars of the industry, and today is just a great opportunity to stay informed on compliance and those sort of topics. So before we begin, I just want everyone to know that right now there's not a handout that's been uploaded into the system for you guys to download. There will be by the time we conclude the webinar. I promise we will get that to you, and we'll also follow up with an email for everyone. So you can click on that link, look at the handout later if you don't download it right now, and share the webinar with all of your colleagues and friends. So without any further ado, I'm going to take a couple of minutes and just let you know, Jeepers, I've heard from hundreds of you over the course of my tenure here at Orange Tree, and every one of you have this one thing in common, and that is you just want to do your job. You want to talk to candidates, you want to fill open positions, you want to focus on your high priority items, such as talent retention, talent acquisition, benefits, a lot of things that are going on in HR that are critical to your employees' health and well-being. Obviously, it goes without saying. And you know what, you really want, simply stated, a peace of mind background program. You want to be able to trust your vendor to get things done so you can do your job. The only challenge to that is there's a problem. Companies are settling for poor performance from the background screening provider. And what do I mean by that? Well, here's what you've told me. You've told me that really table stakes are full services. So you want to have your criminal searches, your verifications, etc., full drug testing options and occupational health, and the ability to, depending upon your requirements, different industries have different requirements. You want to be able to do rechecks and monitor and whatnot. So you need to have these sort of options. And for the most part, many of you told me that you do. The challenge comes, the problems lie in the delivery of those full services. And really what you're looking to do is maximize your productivity. You want to give focus to your highest priorities. And you really want to have peace of mind confidence that your background program is being run by a teammate, a partner who excels in these areas. You want to make sure they have the right technology, the right compliance, and client care or customer service, as the case might be. Well, here's what you've told me. Many providers have two of the three. They may have technology, they may have compliance, but unfortunately, client care it falls short. And what does that look like? Well, maybe the response time is slow. It takes hours, days, just to get a response back, and sometimes it's even from someone who doesn't really have any knowledge about the industry. Maybe they're not dedicated to your account, and so not only is the response slow, but they don't have answers, which just exacerbates the situation. Another situation that you guys have told me about is that you call and you'd like to simply change a package, maybe create a new package, you have new requirements, and there are providers out there, many of them sadly, that don't do that. They don't do it ad hoc. It's very difficult to get done. And then again, if you don't have a dedicated client support rep, that can take a while because you have to bring them up to speed on your company, your policy, and all that sort of thing. And it just kind of slows you down. It keeps you from getting done what you need to get done, filling open positions, working on the higher priority items. So, and finally, another big one, and especially now we see our clients hiring more. The new prospects we're talking to, they're doing more hiring at this time of the year. Given the lockdown, there seems to be some relief out there. It's just really important that you get the most out of your time, that your candidates get the best experience they can. And we found that there's a real frustration in that there are some providers that don't provide direct candidate support. So technology is good, compliance is great, but client service is not up to par, and so that has a real impact on your productivity and being able to get done what you want. And then on the other hand, there's providers in this space that do a nice job with client support. They have a dedicated account manager for you. They are very responsive. They have answers that you need in a timely fashion. They do support your candidate directly, which allows you to keep your tasks there in the office. But unfortunately, their technology just really isn't something that meets your specifications. When you work with a background screen provider, you really want to be able to configure your experience. You want to control that. You'd like to know that your provider really owns their platform, has a development team, and as your needs come up, you know that they're going to be met in a quick time frame. Well, that's not always the case. There are many providers in the industry that work with someone else who provides their platform. And so every time their clients have a requirement to do something to really enhance what they're trying to get done with their background screening program so they can do their job and not focus so much on the program itself, well, they get stalled. They get stalemated because they have to get in line. And it's even possible that their requirements, their needs won't be met over the course of time. So it can be a real problem when the technology isn't there for you. So with Orange Tree, we've known this, and we've been able to work over the course of our company's history, and we really provide excellence across each of these areas. And Heidi is an example of compliance today. She'll exemplify the things that we do here day in and day out. I can assure you that there isn't a product offering, a service delivery that doesn't first go through the rigor of compliance. And another thing that's important for you as you're vetting out your vendors is to ensure that their IT organizations are SOC 2 compliant. You want to make sure that you have data security, data privacy. Almost goes without saying in this day and age, but not every provider does have those certifications like Orange Tree does. So in addition to compliance, I hinted at the technology. We have our own platform. We help our clients configure what they need and in the time frame that they need it. We don't have to wait for someone else. We don't get behind large clients, if you will, or just completely shut out of the process because we don't have a voice with that particular vendor. So we can help our clients with what they need, when they need it, and deliver the experience that they expect from their background provider. And finally, from a client care perspective, we believe we offer excellence here. We have a less than 2-hour response time when virtually every response that a client makes of Orange Tree and their candidates. Not only is the response made, we understand your request, but virtually every time we deliver the answer in that same amount of time. So we really think Orange Tree offers a no compromise experience for the industry. And we think that's important because back to the original point, you all have a job to do. Background screening isn't your job. You are looking to an outside firm in virtually every case to help you with that critical final step in the process. And so you need to be talking to candidates, filling those open positions, meeting the onboarding guidelines, ensuring that the hiring managers have the personnel that they need. You want to focus on the highest priorities, the health well-being of your organization's talent acquisition, retention, benefits, compensation. You don't want to be worried about your background screening program. Are you getting the verifications? Are you getting all of the checks done that you need? Is turnaround time an issue? And really, you don't want to be bogged down with the role of switchboard operator, taking your candidates' questions. That's what your background screen provider is for, what they should be for, and that's what we do at Orange Tree, because really at our core, what we believe is that every company deserves a background screening program designed solely in their best interest. So that's what we focus on all day, every day. A full service provider with a no compromise approach to background screening. We have the technology you need, the compliance you expect, and the client care you deserve. So I would urge you, if you're one of those out there, one of those folks out there, companies that are struggling with your provider, stop. You don't have to settle. You can have it all. You can have the services you need, the delivery that you expect, and you can focus on your job and still get the candidates in the door in the background program that fits your specification. So schedule a call with us. We'd love to tell you more about what we can do to help you. So with that, I will turn it over to Heidi Seaton. She is our Vice President of Legal and Compliance here at Orange Tree, and I will turn over control in just a minute, Heidi. You should now have control of the system.
Okay, hold on just 1 second. Let me just try to advance the screen. Did you see that?
I can see it.
Awesome, great. So hi everyone, again, good to talk to you. As Jeff mentioned, my name is Heidi Seaton. I'm the VP of Legal and Compliance here at Orange Tree. I've been in background screening now in one role or another, but mostly focusing in compliance as of this month for 20 years. So this is my thing. This is what I like to talk about, and I'm looking forward to spending the time talking about these sorts of issues again this quarter. So I do need to stop at this screen for a moment and just remind you all that I'm not your lawyer. This is not legal advice. I always recommend that you seek the advice of your own legal counsel for all matters of employment law and policy. These are important issues. They're highly sometimes controversial and litigated, so do talk to your own legal counsel if you have any specific questions on any of the topics we're covering today. But I do think it's a great opportunity to bring some items to your attention. So here's our really 3-point agenda that we usually cover, so not much of a change this quarter. We're going to talk first about what we're seeing at the state and local level. We'll start in California because, you know, why not? California's special. We have a few updates about their privacy legislation or regulation, and then spend some time on the salary history bans or pay equity statutes, as they're called. We've been seeing some activity there at state and local level this year, and we haven't covered that topic for a while. So we'll loop back on that. Then we'll move on to ban the box or the fair chance statutes that are being passed or coming into effect. And then that'll sort of bring us right into decriminalization efforts, especially around marijuana decriminalization efforts and initiatives that we're watching. Especially, we're seeing more and more that this happens as a ballot measure. And so these are coming up here as the November election cycle approaches. And then on the national side, just a few topics. We'll spend some time talking about the Quest Diagnostics Annual Drug Testing Index Report. Very interesting. It's a big old report. I'll only spend a few minutes on it, but I do have a link to the report for any of our clients and prospects that are doing drug testing that you might find very interesting. Then we'll touch on some changes to the federal custody and control form for, again, those of you doing drug testing, and a quick update on the latest Form I-9 flexibility announcement that came from ICE during this time in COVID. So that's our plan. We'll kind of move right into state and local topics. As I mentioned, speaking about California, we've spent a fair amount of time discussing, thinking about, worrying about, frankly, the CCPA, California Consumer Protection Act, that was passed last year, and the CCPA included an exemption for human resources data. That original exemption was set to expire here first of the year 2021, but we did see in California AB 1281 that got signed into law at the end of September that extends that exemption for another year. So good news, I think, for employers from a burden standpoint. Full CCPA compliance, it's a lot. There's a lot that employers would need to do. Carving out this human resources data for employers, I think, does really help. Don't forget, though, the exemption does not apply to a couple of items. First, employers have to provide HR individuals, and we'll define that here in a minute, with a notice at collection. So when or at the time of or before collecting your individually identifiable information, the notice has to describe the personal information the company will collect about these individuals and the purpose for which they'll use the information. HR individuals is defined as California residents in their capacity as applicants, employees, contractors, owners, directors, medical staff members, emergency contacts, and employees' dependents or beneficiaries where they're receiving company benefits. So keep those things in mind. Keep that notice requirement in mind. The second part of that is still applicable even with the exemption extending to 2022 is that even HR individuals have a right to recover statutory damages. So making sure you've got this notice of collection process in place is super important.
Hey, Heidi.
Okay.
Yes. Can you just double check, make sure your microphone's on?
It is on.
I can hear you fine, but we just said, okay, go ahead.
Okay. The second item for privacy in California is that the state also in September passed AB 1864, which creates or renames, I guess actually, but creates the California Consumer Financial Protection Law, which created the Department of Financial Protection and Innovation. There is already a Department of Business Oversight, and so that department is renamed with this passing of the bill. It expands authority to enforce and regulate, and it describes being able to oversee unregulated industries, including, among others, consumer credit reporting companies. I would seriously question the definition of consumer credit reporting companies as unregulated in California. I think that's interesting language, but we'll see where this goes from an enforcement and regulatory standpoint. It does specify consumer credit reporting agencies or companies, so it will be interesting to see whether they intend to carve out consumer reporting agencies that are not also credit reporting agencies. But in any case, the name change is effective immediately. Their enforcement and regulatory authority becomes effective here at the beginning of January 2021. So those are the two privacy topics to cover, and then we're going to move into ban the box. So, we're going to move into salary history bans or pay equity laws. So for those of you not familiar, it's been a little while since we talked about these, but they are laws that are intended to limit when and whether employers can ask a job candidate about their past earnings. In general, they're just intended to prevent employers from basing compensation on previous earnings. So this is sort of an anti-discrimination effort. We're aware of 19 states that have passed statewide laws. In addition, there's a number of cities that have also enacted these types of laws. And we did see a fair number of these moving forward in the first half of 2020. So we wanted to make sure that if you are an employer that is still collecting salary history information as part of your pre-employment process, that you're aware of these limitations. The first one is New York. New York actually passed a law about this back in 2017 when these sorts of statutes first became sort of popular. And this is an amendment. So this amendment applies to public and private sector employers. It was effective right away at the beginning of this year. And the amendment clarifies that the salary history ban applies to all jobs within the state, even if the employer does not maintain a workplace in the state, and that it also covers current employees and candidates for hire. Interesting. So employers are prohibited from asking prospective or current employees then about their salary history and compensation, and they also may not seek that information from other sources. So for instance, they can't ask their background screening company to try to get that information for them. The New York ban or pay equity statute carves out independent contractors and freelancers. But I did want to just draw attention, New York City, part of their human rights law does afford protections to independent contractors and freelancers. So New York employers, just be a little bit careful that you're taking those New York City human rights law requirements into consideration as well if both of those apply to you or to your work location or to your employees. Maryland also passed an amendment to its pay equity law. This one became effective here in October of this year. It does apply to private, state, local government employers. And this statute requires that upon request, the employer must provide a wage range for a position to which a candidate has applied. And then employers are prohibited from retaliating against candidates that request it. They're prohibited from making inquiries into the candidate's compensation history, at least for the purposes of setting compensation. Although they may use salary history information if it's voluntarily given. If you are going to voluntarily receive pay history information, just be super careful about using it and then documenting how you came to have it, because that voluntarily given issue seems to me could be problematic for employers to show. Let's see. Even more local. So as I mentioned, we have a number of states that have passed pay equity or salary history ban regulation statutes. We are also seeing this, as I mentioned, at the city level. Again, this one happened in Toledo, Ohio. The act was signed in July of 2019. It had a nearly year-long delay before its effective date, so I wanted to bring it back up here today. That went into effect June of 2020. It applies to employers that are within the city of Toledo that employ 15 or more employees also within the city of Toledo. So probably a fairly narrow applicability as far as employers that are affected, but it prohibits employers from inquiring about, screening, or relying on salary history in making that offer of employment. Interestingly, they carved out current or past employees. So if you have a current employee that's applying for a different job or being promoted, or if you have a past employee who's coming back to you, you can use basically your own salary history information. And then there is some carve out for voluntarily disclosed compensation. So you can't use it in deciding whether or not to offer the position, but you can verify it if it's voluntarily disclosed. Again, I find the whole voluntarily disclosed question problematic for employers, so just be really careful about that. It does include an anti-retaliation provision. Again, this one is effective even now. And then another local city. This ordinance actually was passed in 2017. Some of you may remember. I think they were one of the first actually, but it sort of immediately as it was passed, it was challenged in court as an unconstitutional limitation of free speech. That worked its way through the court system, and in June of this year, we actually had a decision from the U.S. Court of Appeals, the Third Circuit. They upheld it. They said, nope, it's not an unconstitutional limit of free speech, and the city began enforcement then on this ordinance in September. So again, just remember in Philadelphia, employers prohibited from asking applicants applying for a job in that city about their current or prior salary history or using information to determine wages. So that was our salary history ban topics. We're going to move now into fair chance and ban the box. The trend continues. Just as a little reminder, ban the box laws or fair chance laws restrict employers from inquiring about an applicant's criminal background at some or another stage of the hiring process, and they vary, right, from jurisdiction to jurisdiction, from location to location. The when of when an employer can make that inquiry varies usually, and most recently we see that having to wait until after the conditional offer of the job. The purpose of the law is, of course, to enable an ex-offender, for instance, to display their qualifications in the hiring process before they have to disclose a criminal record. And then also on the topic, before we get into the changes here, a reminder, there's currently no federal ban the box law that is generally applicable to private sector employers. Recall though, we did last year have the Fair Chance Act, also known as the Fair Chance to Compete for Jobs Act of 2019. That was a federal law that was enacted, but it was limited in its scope. It prohibits federal agencies and government contractors from inquiring about an applicant's criminal history before making that conditional offer of employment, with some exceptions. So in general, most non-government employers are looking to state law or local jurisdictional law to determine whether or not they have a fair chance or ban the box ordinance that's applicable to them. So that's why we keep talking about these state-specific and city and county-specific changes. North Carolina, so this was an executive order. It affects only state government employers, so no applicability to private sector employers. So for state government employers, effective date here, November 1 of 2020, you've got a few more days. Such employers are prohibited from asking about criminal history on the employment application or during the initial stages of an employment decision. A little vague, unfortunately, but something after the initial stages of that decision. And then they're specific about when the criminal history check can happen, and that's not until after an initial interview. And then they also lay out a few things that employer may not consider regarding criminal history. So goes a little bit further than some other ban the box or fair chance ordinances, although we are seeing a trend here. It used to be initially when ban the box laws were passed, it merely took the admitted to criminal history question off of the employment application and moved it to some later date. But as more and more of these are passing, we're seeing more prohibitions or things that employers have to be careful about. And they tend to be around things like not just when the question can be asked, but when the criminal history background check can be initiated, and then when it is initiated, what sort of information can be considered. And then we also sometimes see cases where the law has additional requirements for the adverse action or pre-adverse action process if the employer is considering not hiring someone based on criminal history. So this one is just affects when the question can be asked and when the criminal history check can be run and what charges an employer can consider. I don't see anything in there regarding additional adverse action requirements. Hawaii, actually, they long have had a ban the box legislation, so they were one of the first. But they passed an amendment here in earlier this year, SB 2193, and this one actually affects the look back period. So this amendment is specific to how far back an employer can look at criminal history information when they're making their hiring decision. So this one went into effect here in September, and it does affect private sector employers. So not just government employees, but private sector employers as well. And it creates a 7-year, 5-year look back period, and an employer can no longer consider felony convictions that are older than 7 years or misdemeanor convictions older than 5 years. And in that 5-year, 7-year calculation, employers may include periods of incarceration. So it does attempt to allow the employer to consider those cases where incarceration would push the age of the record out further there than perhaps the 5 or the 7 year period. Has all sorts of exceptions. Most of the exceptions are for state employment, education, police departments, people with direct contact with clients in healthcare. There are more exceptions, so if you are an employer in Hawaii, do take a look at that to see if any of those exceptions apply. And then in Shelby County, Tennessee, so an example here of a local ordinance. So the Shelby County Commission passed this unanimously, and in this case, the limitation applies only to Shelby County government positions. So pretty limited in scope here, but took effect back in July. And the result of this, the way that they implemented the county, will no longer ask about arrests or convictions in the employment application. And they do, of course, have an exception, pretty broadly, pretty broad language used in this exception, actually. They said if the criminal conviction would substantially relate to the potential job duties, which I think you can make a pretty good case there for most jobs, but that's complete speculation on my part. They provided examples of corrections positions or where required by state or federal law. So that's beyond the box, and now we're going to start moving into more of the drug testing topics, particularly decriminalization of marijuana. We'll start there. Virginia signed their bill in, they passed their bill signed by the governor in May. They have decriminalized simple possession of marijuana. So what used to be a misdemeanor is now a record that is civil in nature, so it's no longer criminal in nature. It's a civil penalty, and this change is effective as of July, and it prohibits employers from inquiring or requiring applicants to disclose an arrest, charge, or conviction for simple possession of marijuana. So a change there. It will be interesting to see if the Virginia court system will go back and update all of those records. I suspect they will not. I suspect that it will just be a change and in the statute, and it will be moving forward. But I also suspect that the change to it being a civil in nature will include historical records. So we will start to look for now simple possession of marijuana coming into our system. We will look to see if it meets that criteria of becoming a civil penalty and not a criminal case, and begin to exclude those records from our criminal research services. And then the rest of these that I'm going to talk about related to drug testing are really more about either creating a medical marijuana program or legalizing recreational use. And what we are definitely seeing here this year, especially this year with COVID, and there wasn't a ton of state legislative, let's say, progress this year. So what we're seeing more and more often are propositions or state constitutional amendments to move these programs forward. So we do see a number of these coming up on the November ballots. For instance, Arizona, they have the Smart and Save Arizona Act. It would legalize marijuana possession and recreational use by adults age 21 and over in Arizona. This is non-medical use, possession and recreational use only. They currently have a Arizona Medical Marijuana Act, so this would be in addition to that statute. And the purpose is, at least part of the intended purpose of the proposition is to create a framework for cultivation and sales. So look to see if this does get past a fair amount of regulatory activity from the state around that sales and cultivation. Right now, as drafted, the proposition doesn't have any express language or protections for applicants or employees' use of marijuana in the drug place. It doesn't explicitly prohibit employers from testing for marijuana. Again, I would also expect to see some regulation come into play if the proposition passes. That Medical Marijuana Act, by the way, does contain employment protections for cardholders, so the two laws would have some different applications. Mississippi has two initiatives that we're watching. So Initiative 65 was a citizen-driven ballot. 65A was referred to the ballot as an alternative measure by the legislature. So we'll follow both of those. Neither contains right now, again, as drafted, neither contains an express protection for applicants or employees for marijuana use, nor does it prohibit employers from testing. And I'm sorry, I should have mentioned earlier, Mississippi, both initiatives here are related to creating a medical marijuana program. Montana has introduced a couple of ballot initiatives as well. They have a statutory initiative and a constitutional initiative. Both would legalize marijuana possession and recreation, again, non-medical, for use by adults in Montana. The statutory initiative has no express protections for applicants or employees, nor does it prohibit employers from testing. And then the constitutional initiative would amend to allow for a minimum age for legal use, possession, or purchase. So a little bit different. There is a medical marijuana use law already on the books in Montana. So it'll be interesting to see, again, if the recreational initiative, one or the other, both, pass, and how that will play with medical marijuana. Again, it's not uncommon to have both and to have sort of obviously different rules applying, and obviously also different applicability as far as how employers can consider and use the that information or positive tests. Nebraska also kind of has a constitutional amendment on the ballot. It's actually being challenged right now in the Nebraska Supreme Court, or it's being challenged. We expect that the Nebraska Supreme Court will have to decide whether the initiative meets the single subject criteria of a constitutional amendment under Nebraska law. But if it does reach the ballot, the topic there is to legalize marijuana for medical purposes, and then if so, authorize the legislature to develop a structure for it, right? So laws, rules, regulations governing the medical program. Again, as written, the amendment does not have any express protections for applicants or employees, and it doesn't prohibit employers from testing. But I would sort of expect to see that if it passes, if the amendment makes it to the ballot and if it passes, I would expect to see that rule and regulatory process coming from the legislature to touch on those topics. Who knows? We'll watch and see. But we'll probably have an update on all of these state ballot initiatives in the Q1 review. New Jersey has a constitutional amendment called Public Question 1 on the ballot. Again, looking to legalize possession and recreational use for adults over the age of 21. Also has language to place limits on how much sales tax can be collected. Again, if passed, I think we're likely to see further legislation and regulatory framework being created. But as written so far, there's no express protections for applicants and employees, and doesn't prohibit employers from testing for it. There is a current medical marijuana law on the books there that does provide employment protections for card holders, just a reminder there. And then South Dakota, I think this is our last one. South Dakota is unique. It currently has neither legal, medical, nor recreational marijuana. So voters will be voting on both in November. It's called Measure 26. Measure 26 is for medical marijuana, and then Constitutional Amendment A is the recreational marijuana effort. Has a fair amount of language about would still prohibit undertaking any task under the influence when doing so, under the influence of marijuana, by the way, when doing so would constitute negligence or professional malpractice. So some language that should be interesting to employers. Prohibits operating any motor vehicle when under the influence of marijuana. But again, sort of a carve out there for registered medical marijuana users, and it'll be interesting to follow these. It also talks about the fact that just because a registered user is registered, they're not considered under the influence solely because of they have cannabis metabolites, if those metabolites are in insufficient quantities to cause impairment. So for me, if I'm an employer, that's problematic language for my post-accident reasonable suspicion testing, because insufficient quantities is hard to quantify. Use that word a lot. Okay, so that's what I had to cover at the state and local level. Moving on to some topics of interest at the national level. I think we talk about this every year. I've included a link to the site to go get this report for yourself, but Quest Diagnostics, the drug testing lab, they do an annual drug testing index. It's fascinating information. They report on the previous 5 years. So 2020 actually covers up to the year 2019. So I know 2020's gone so quickly, but they're about a year behind in their reporting, but as you would expect, they're reporting on a full year. They provided this lovely set of graphics here. So feel free, get to the link and go and read the entire report yourself. Just a couple of highlights. It doesn't seem like good news for employers in general. Even if you just look at the graphs, this is by sector. I think there's 3 or 4, 1, 2, I feel like there's a third one here somewhere. Very few sectors where positivity rates have gone down from last year to this year. Their analysis, backs up the graph, right? So they say positivity rates in the U.S. workforce increased in urine drug testing. They are at their highest levels since 2003, and more than 20% higher than the 30-year low, which was recorded in 2010 and 2012. So not great news for employers that are using drug testing to create a safe work environment. Dramatic increases in positivity for cocaine, methamphetamine, and marijuana, especially in the Midwest. So that's interesting as well. And let's see, increased rates of positivity for methamphetamines, both in urine testing as well as oral fluid testing. Cocaine positivity increasing in the Midwest and West region over the last 5 years. In general, positivity for opiates in urine drug testing continues to decline. So that's interesting, as we've seen more regulation of, I think, probably prescription or prescribing and access to opiates. So good trend there. Marijuana continues to top the list of most commonly detected illegal substances across all of the workforce categories and in all of the specimen types. In general, marijuana positivity increased nearly 11% from 2018 to 2019. So it was at 2.8% in 18, up to 3.1% in 2019. Good news, heroin rates, positivity rates for heroin continue to decline, both in general and also in federally mandated and safety sensitive workforce testing. So again, fascinating information, a great resource. They do, Quest Diagnostics does just a really significant amount of drug testing, workforce drug testing in the US. So a great resources for employers to be taking a look at. The link is there if you want to go look at the whole report yourself. Speaking of drug testing and particularly federal, at the national federal level, the DOT custody and control form has been revised. Most of the changes were adopted to accommodate the use of oral fluid specimen testing in some federal programs. Please do not read that to mean that oral fluid is now authorized for DOT testing. That is not yet the case, but we really do expect to have that approved soon. We expect guidance to be coming out soon for using oral fluid testing in DOT programs. I mean, we've been saying this for a while, but it could actually happen this year. I think it will actually. The changes include adding a place for CDL state and number on the custody and control form. That's specifically for the Federal Motor Carrier Safety Administration regulated driving positions. They added an other field to the collector contact information area to get an email address for a collector. They added a field for the donor to provide an email address. So that's good progress. Feel like the form is coming into, well, the last century anyway. And there's a few other changes. So if you are really interested, just take a look at the SAMHSA website. So that's samhsa.gov for additional really specific changes. So use of this new form is authorized as of September 1st of this year, but labs aren't even printing them yet. So there's a backlog of the old form. The DOT doesn't allow for oral fluid testing yet, and so I don't actually expect to see the labs start printing these or making these available for, I would guess, a quarter, 6 months even. And the notice of change made clear the old version, the current version can be used for the next year. So through the end of August of 2021, I expect that will be the case unless or until we see oral fluid approved for DOT testing. And then I think we'll actually, that would accelerate the use of the new form with the labs. Okay. And then one last topic to cover here. You may remember when we last met, we talked about that Immigration and Customs Enforcement agency had provided some guidance that would allow employers to use virtual work authorization document inspection instead of in-person work authorization inspection, and they put a deadline on that. And so this is just on September 15th, ICE announced an additional 60-day extension. So employers that are affected, that is now extended until November 19th of 2020. It'll be interesting. We might see another extension. I wouldn't be terribly surprised. But be careful, employers. It's very limited. This flexibility, as they call it, allows employers whose operations or a particular site remains shuttered or otherwise closed to review identity and work authorization documents virtually rather than in person. This is only a temporary reprieve, so I do expect when this extension is expired that ICE will expect employers to go back and physically inspect those documents that they inspected visually during this time of flexibility. And certainly after that time, they'll have to need to begin physical inspections of the documents again. And so if you're taking advantage of any of these exceptions, of this exception in particular, be sure that you're documenting the fact that you are doing it and that you're doing a virtual inspection instead of a physical inspection of the documents, and the specific reason or exception that allows it. Make sure you're documenting that and keeping that along with the form. And then E-Verify, as soon as ICE came out with this extension announcement, E-Verify chimed in to remind E-Verify participating employers that they must still initiate that E-Verify process for new hires within the 3 business days from the date of hire. So no extension or flexibility on the E-Verify side of this for employers that are participating in that E-Verify program. So that's what I have. This last page here, I think just a good reminder, I'm available. That's my direct email. Jeff's contact information is on here. There's also some links to our blog, our website, some videos, description of services on the slides. But Renew or Jeff, I think that's all I have to cover today, unless there was a particular question. Jeff, are you muted? I can't hear you.
Maybe I am muted.
Okay, sorry, should have said something sooner.
Muted and cannot hear. So maybe it was best that you couldn't hear me. That's typically what many say. So let me just say this. If for all of you still here, if you have any questions that come up, you review the notes and you're just thinking, jeepers, how does that apply to me? Send an email to Heidi's point to any of us, and we will, or your client success partner here at Orange Tree, will definitely, and sometimes in situations of compliance, it's even a little bit better to have a one-on-one conversation, because we can really hone in on your specific situation and help you to a little bit more of an nth degree, if you will. So Heidi, thank you very much for a terrific job. Lots of updates, a lot of things continue to move forward in the world of compliance, and we appreciate the work that you do. To everyone who joined us today, that you are eligible for SHRM credits. If you have any questions about that, you can send us an email or Ray Newberg, rberg@oats.com. We'll make sure that you get that. And there will be a follow-on email that you can send to your colleagues. So without any further ado, thank you very much for attending. Have a great Thursday.
Thank you.